Hello, everyone. Welcome. We'll get started in a moment. Good to see everybody. This important topic today. All right, so while we are still waiting for people to arrive, it is at time, maybe even a minute past. So I want to go ahead and get started so we can make full use of the time that we have here together. So now I know most of the people on this call are NACCED members, but I do want to reintroduce myself and us as we get started. So I'm Laura Petty, I'm NACCED's Executive Director, and we wanted to organize this call because we have been getting a lot of questions around, started with DEI directives, then the federal funding freeze, and now we're discussing and monitoring what's happening at a staffing level with HUD. So NACCED is the National Association for County, Community, and Economic Development. We represent local governments, specifically those with federally funded affordable housing and community development programs. So we have a speaker with us today to address some of those topics. So for those who were who attended our legislative conference last year in 2024, we had Professor Richard Pierce speak with us then. Then the topic was Supreme Court cases related to affirmative action. So plenty has happened since then, as we know. Richard Pierce is the Lyle T. Alverson Professor of Law at George Washington University School of Law. He's the author of over 20 books and 130 articles on administrative law, government regulation, and the effects of various forms of government intervention on the performance of markets. So he is an expert in administrative law. We really enjoyed having him with us last year, and we're excited to welcome him back here again today. So with that, I'm going to turn it over to Professor Pierce. He's going to go through a couple of things. He's got his own talking points to share with you all, and then we're going to open it up for Q&A. Feel free at any point to put your questions in the chat if you would like. You can also raise your hand, use the raise your hand function. And with that, we will get started. So I'll turn it over to you, Professor Pierce.
Well, thank you very much for inviting me to do this. And I just wish that I was in a position to provide more definitive advice and more optimistic advice. But to the extent that I can provide definitive advice, it isn't very optimistic. And mostly I can't provide a lot of definitive advice. So let me break my talk into 5 general topics, and then once I've through describing each of those general topics, I'll be glad to do my best to answer any questions that anyone has. And the first topic I wanted to address is DEI, because it's one of the few on which I can really provide definitive advice. If you haven't already received, I gather that most, if not all of you, are operating in an environment in which you're dependent on federal funding to in some way through some device. So if you haven't already gotten the most recent version of the DEI letter from the Trump administration, you soon will. I've now read half a dozen of them, and they all are just about the same. And what they say is, get rid of everything that bears any resemblance to anything you've done in the past in the DEI context. And they rely on a very aggressive interpretation of the Supreme Court's opinion in 2023 in Students for Fair Admission against Harvard. And the letters go on for pages, typically, in describing all of the things that you can't do. And while I think that their interpretation of the Supreme Court opinion is a little over the top in some respects, I'd advise everybody to do whatever the hell they tell you to do on it, because most of what they say is supported in the opinion. And even if you were somehow to challenge it and then prevail at some point, you would pay an enormous price, because for whatever reason, this administration has put anti-DEI right at the top of its priority list. They want to eliminate anything that bears any resemblance to DEI. And I think you're better off whatever you personally or your organization might feel about it, just to go along with them and not to fight them on that issue. So I think it's likely to be a losing battle, and it would certainly be a losing battle as a practical matter, because you would be viewed as persona non grata by everybody in the Trump administration, and they would do everything within their power to put you and your organization at a tremendous disadvantage. And they have a lot of powers. So that's topic one I wanted to address, and one of the very few on which I can provide definitive advice. So the next topic I wanted to address is really an overview of, I feel very, very sorry for all of the judges and justices who now are in an extremely difficult situation. Over this first few weeks in office, the Trump administration has made somewhere between 75 and 100, taken 75 to 100 actions that are dubious, that are in some cases not clearly supported by a statute, in many cases are even violative of a statute, inconsistent with, clearly inconsistent with a statute. And what they're arguing in every case in which they're acting in a manner inconsistent with the statute, that the statute is unconstitutional because it's inconsistent with the vesting clause of Article 2 of the Constitution. Each of these cases raises very, very serious questions, very serious issues, always about the meaning of statutes, or mostly about the meaning of statutes, but also about the meaning of the Constitution in many contexts, and the meaning particularly of the vesting clause of Article 2 of the Constitution. So each of these issues should be the subject of lengthy deliberation, briefing, and oral arguments and research, first in district courts, and then in circuit courts, and then in the Supreme Court. That process for any one of them would take 3 to 5 years. And we don't have 3 to 5 years. The country doesn't have 3 to 5 years. These actions, if they are going to go into effect, are going to go into effect now, or within days after the announcement of the action. And that puts courts in a horrible situation. They cannot decide the merits of any of these cases in less than, say, 3 to 5 years. The most they can do is respond to motions for preliminary injunctions. So somebody doesn't like something that the Trump administration has done, they go to court, and what they're doing initially, of course, is going to courts that they expect to be sympathetic to their perspective and unsympathetic to the views of the Trump administration. And that would be the First Circuit in Boston, the Second Circuit in New York, the Ninth Circuit in San Francisco and Seattle, and the DC Circuit. Okay, they're surely not going to go to places like the Fifth Circuit that are loaded with judges that are sympathetic with everything that the Trump administration is trying to do. So they're going to go to one of those courts that they expect to be sensitive to their position in opposition to the Trump administration, and they're going to move for a preliminary injunction. And there's going to be big questions about the scope of the preliminary injunction. Will it be nationwide in effect, or will it only affect the parties to the action? There's been a lively debate about that for 15 years that the Supreme Court has never definitively resolved. And then lots and lots of debates about the most important factor in deciding whether to grant a preliminary injunction is whether you think that it is likely Okay. You're not resolving the merits of the dispute, but whether you think it is likely that the petitioner, the complaining party, will eventually prevail on the merits. Okay. So I expect that a high proportion of those cases will be successful. In some cases at the district court level, in some cases at the circuit court level. But they'll always, even if they start in the district court, they'll go to the circuit court. And those circuits, the first, the second, the ninth, and the DC circuit, tend not to be sympathetic to the views of the Trump administration. So in many cases, they will issue preliminary injunctions of some sort. The next thing that will happen after that, and it's just happened in the first case, it's going to happen in I think almost all of the cases, is that the government will be displeased with the issuance of the preliminary injunction by the district court and the decision upholding it by the circuit court, and they will file a motion on the Supreme Court's emergency docket. Well, the Supreme Court's emergency docket used to be a very, very rarely used docket up until 7 or 8 years ago. It was only used for circumstances like somebody's scheduled to be executed in 2 days. Will the Supreme Court say, well, hold it off until the courts get a chance to decide the merits of whether the execution is warranted? Well, over the last 6 or 7 years, the Supreme Court has started to use the emergency docket far more frequently. What typically happens on the emergency docket is the party who's displeased with the lower court's opinion, and that in most cases is going to be the government, who's displeased that a district judge with agreement from a circuit court has issued a preliminary injunction saying that at least for now, the Trump administration cannot do that which it wants to do. And then there's a response from the complaining party. In many cases, that will be the attorney generals of all of the democratically controlled states, or in some cases, a public employee union. In other cases, an individual who has been injured by the action that is at issue. And then the Supreme Court, with no oral argument and based solely on those, the motion and the response to the motion, will say yes or no. If it says yes, then that means that the district court action enjoining the Trump administration from taking the action is in effect until such time as the courts resolve the merits, which could be years from now. If the answer is no, what that means is, well, this might be more confusing than it should be. If they uphold the preliminary injunction against the administration, the government goes to court and asks them to overturn it, the Supreme Court, and asks them to overturn it on the emergency docket. And they either do or don't. And typically that's done with very little deliberation and no opinion. And it's kind of understandable because deciding the merits of one of these cases takes years of careful deliberation and debate and research. And so all they're deciding in theory is, what do we do in the meantime before the courts issue a final decision on the merits? The problem is the process of issuing a final decision on the merits takes years. So even though in theory, these motions for preliminary injunction are only temporary, they are usually permanent, at least permanent in high proportion of cases, because the facts on the ground are already done by the time the courts get around to the merits. And it's really regrettable that the court makes these decisions on its emergency docket, typically with no opinion that tells you why they have decided either that a preliminary injunction should be upheld and the government should continue to be enjoined from taking the action that it is attempting to take, or whether instead the preliminary injunction is vacated and the government is free to go forward with whatever it proposes to do. And there's a very high proportion of these 50 to 100 cases that raise very serious issues that should be the subject of great deliberation, and that are very difficult to predict in terms of the outcome on the merits. Well, they're also very difficult to predict in terms of the outcome of the preliminary injunction motion on the Supreme Court's emergency docket. And even after the Supreme Court decides one way or the other in each case, we won't know why the court acted as it did, because it rarely issues an opinion when it acts on its emergency docket. When it acts on its emergency docket, the terms of the order typically are this decision will remain in effect until such time as either we, the Supreme Court, issue a final decision on the merits, or a circuit court issues a final decision on the merits, and we, the Supreme Court, deny a petition for writ of certiorari. Well, that's years. And in many administrations recently, these have been overtaken by elections. So the disputes become moot. If there's an election and the new president reverses all the policies decisions of the prior president, as has become now routine as a result of presidential elections. So the bottom line is the courts are being forced to do things that they don't like doing, for sure, and that really forces them to make very quick decisions without nearly the kind of research, consideration, and deliberation that they usually engage in. So that was my second point. I feel sorry for the judges and justices who are now in that situation. Oh, I should add one point. The first of those is on its way, has already arrived at the Supreme Court, and that involved the decision to remove a fellow named Dellinger, who was an officer of the United States who was responsible for overseeing the whistleblower program and ensuring that whistleblowers are protected. And he was removed by Trump, and he's appealing that. I expect him to lose, and I don't count that as one of the really difficult cases, because there's already precedence on the administration's side on that issue. So I don't see that as a big test case. The test cases are going to come in the next few weeks or months. There'll be a whole lot of them that give us a better feel for how the Supreme Court is going to handle these. So the third point I wanted to address is I also feel sorry for the lawyers who are having to defend the government in these many actions. Here's what's happening on a fairly regular basis. The complaining party, say the lawyer representing all of the attorney generals in the Democratic controlled states, that's often the complaining party, comes in and says, the government did X, and we believe that's illegal for the following reasons. And the initial response of the government lawyer is, we didn't do X, okay? And we did Y instead of X. And then the government lawyer, a day or two later, comes back to that same court and says, oops, when I got back to my agency, I discovered we had, in fact, done X. So this is just reflective of the tremendous amount of confusion that exists within the Trump administration, and how difficult it is even to figure out, even for the lawyers who are trying to defend the administration's actions in court, to figure out what the administration has actually done. So that was the third topic I wanted to address initially. The fourth is the status of the many employees who are being terminated, who have already been removed or terminated, or are about to be removed or terminated, and there's going to be many, many more actions of that type. And the best I can do is tell you that I'm part of a listserv that's comprised of administrative law professors all over the country who share information about what's happening in each of these actions and about the kinds of defenses that are available to the employees. And I can tell you that it is an incredibly complicated legal environment. You can divide federal employees into at least a dozen different categories. And some of those categories are employees that are very easy for the Trump administration to remove or terminate without cause and quite quickly. Others are subject to lots and lots of limitations, many of them statutory limitations on the circumstances in which they can be removed. And what the Trump administration is arguing in case after case is none of these statutory restrictions should impede us, impair our power, because they're all inconsistent with the vesting clause of Article 6 of the Constitution. Well, what I can tell you about the vesting clause is it was viewed as not having a whole lot of significance until about 15 years ago, and the conservative majority of the Supreme Court over the last 15 years has interpreted the vesting clause to have very broad effects in a lot of contexts. And what we don't know at this point and can't know at this point is how far the conservative majority of the Supreme Court is willing to go in terms of its interpretation of the vesting clause. If what it has said in half a dozen cases, in half a dozen contexts over the last 15 years is this statute says the president can't do X, or can't do X unless he does something like stating a cause to remove someone. And we hold that is unconstitutional because it is inconsistent with the vesting clause of the Constitution. So the court has shown that it is receptive to arguments of that type in some contexts. We don't know how receptive it is. And it's going to be confronted with many, many cases, many of them involving federal employees of various types and various categories, in which it has to figure out whether the vesting clause of Article 2 is so powerful that it overrides whatever statute is providing some sort of safeguard for the employment status of the employee. And the best I can do right now is tell you that we have so far, the group that's doing this, and hundreds of lawyers, hundreds of law professors, has been able to put federal employees into over a dozen categories. And the decision to terminate or remove many of the categories raises scores of very important constitutional law issues that have never been resolved. Okay? They're totally unprecedented. So it's anybody's guess how the Supreme Court is going to resolve them, and we all engage in that guessing game from time to time. But whether it's going to be 6-3 this way or 6-3 the other way, nobody knows for sure. It's just a guess. And then the final point that I wanted to make was respect to spending, federal spending. So as I'm sure most of you know, I'll give you the thumbnail history here. Presidents actually frequently over the course of 200 years would decline to spend money that had been appropriated by Congress for various reasons. One of the famous ones was back in the very early days of the Republic when Congress appropriated funds to construct a dozen gunboats to deal with some serious and growing international conflict. And the president said, no, we're not going to spend it because by the time they got around to needing to spend it, the president concluded that the threat from abroad had abated to the point where it didn't make any sense to spend that money. So that's just an illustration of what was commonplace from 1789 until 1974. And then Richard Nixon decided that he had a lot of battles with Congress during his administration. And he decided to use this as a way of circumventing Congress, basically. So if Congress said, we hereby appropriate so many billions of dollars for a particular purpose, Nixon would just say, I disagree, I won't spend it. And the courts backed up Nixon on that. And then Congress got so upset by the way that Nixon was using this impoundment process that they passed the Impoundment Act in 1974. And what that act says is very simple. It just says, except for some minor variations, whenever Congress appropriates funds, any court should interpret that appropriation as we hereby authorize the executive branch to spend this money, and the executive branch must spend this money. Okay, so that changed the situation dramatically and gave Congress much more power vis-a-vis the executive. Well, that statute has never been challenged. Everybody just assumed that it was a lawful exercise of congressional power, legislative power, until the Trump administration, the second Trump administration arrived. And they argue, as they're arguing in so many other cases, the vesting clause of Article 6 is inconsistent with the Impoundment Act of 1974. Thus, you, the courts, should hold that the Impoundment Act is unconstitutional, thereby allowing me, President Trump, complete discretion whether to spend appropriated funds. Not that he would have the discretion to spend money that hasn't been appropriated, but that he would have the discretion then to choose not to spend money that had been appropriated. This is one of those big constitutional issues that should come before the Supreme Court after it has been the subject of great research and deliberation in multiple district courts and multiple circuit courts, and then eventually should get to the Supreme Court, and then the Supreme Court justices should engage in lots of research and deliberation and consideration, and then should come up with a decision. Again, that's a 5-year process. We don't have that kind of time. And so this is another case where that enormously important, unprecedented constitutional decision will have to be made initially in the context of the decisions to grant or not to grant motions for preliminary injunction in district courts, then the circuit court decisions, and I expect that almost all of those are going to be favorable to the petitioners and against the government, and then what the Supreme Court does on its emergency docket with that incredibly important question. And that's another one where, all of us who are in this game, in the sense of trying to teach students what the law is, differ in terms of what we're predicting. Some think, I think nobody thinks it's going to be unanimous. Okay, so the guesses are 7-2 one way or 6-3 the other way. There are 5 justices that are easy to predict, and 4 justices that are incredibly difficult to predict, and so we're just engaging in guesswork, and we will get the answer to that at least on a tentative emergency basis sometime in the next few months from the Supreme Court. So that's what I have to say initially, and I'm happy to do my best to answer any questions anybody has, as long as you understand that my answer in many cases will be, I don't know, and no one knows, unless they could read the minds of 4 Supreme Court justices.
Yeah, thank you for that. So we will open it up for questions now. You're welcome to put your question in the chat or use the raise a hand function, and we'll see you, call on you. One question that I had was around what the Department of Government Efficiency is doing and kind of where they get their legal authority from. So reading a little bit about it, I know that it's a repurposing of the U.S. Digital Service. So I don't know if the audience broadly knows that. So can you talk to us a little bit about the government reform efforts that are coming out of DOGE and that history with the U.S. Digital Service that was an entity created by the Obama administration?
Sure. There are a number of ways you can think about DOGE, and more specifically about it. I mean, what we're really talking about is Elon Musk, because any power that any of those kids he's got running around at all the agencies, any power they have is derivative of his power. So some people say, well, he clearly has the power to do what he's doing because he's not doing anything except advising the president. Okay, so a lot of people analogize what he's doing to the actions of the president's chief of staff. Okay, the president's chief of staff is not confirmed by Congress. It's just somebody the president chooses because he appreciates his advice. And the chief of staff has no power to do anything, nothing at all. He has no power at all, except every time he opens his mouth, everybody assumes he's speaking on behalf of the president. Therefore, he has all the power of the president. Okay? And so that way of thinking about DOGE and Elon Musk's role is, well, it's 100% derivative of the power of the president and entirely dependent on the president continuing to say, well, whatever Elon does and what one of his young employees does is he's exercising my power, and I'm 100% behind it. If and when that changes, then Elon Musk has no powers at all of his own. Another way of looking at this is a more formal way, where you start looking at the extent to which somebody in the federal government, in the executive branch of government, including the president, delegates some of their power to someone else. And there's a very complicated body of law applicable to the circumstances in which anyone, including the president, can delegate their powers to someone else. And as soon as you get into that debate, you are often running in a world in which only a dozen or so lawyers are qualified to play the game, because you're talking about how best to interpret a 1795 statute, a statute that Congress enacted in 1795 and an 1898 Supreme Court opinion. they arose in particular circumstances, and we know how they applied in those particular circumstances. But how in the world they apply today, and the extent to which they limit the power of the president to delegate his powers to others is an open question, and it's very, very difficult to interpret the combination of the 1795 statute and the 1898 Supreme Court opinion. So this is another of these cases where, if at any point Donald Trump says, "I've now decided I hate Elon Musk and he's no longer acting on my behalf," well, that's the end of the game. And of course, he's done that with respect to hundreds of people that he had in various high positions from time to time. So that could happen at some point, at which point he has no power at all. But as long as Trump keeps saying, as he has been so far, every time he's acting on my behalf, it's going to be hard to block any action that he takes, because what you're really trying to do is block an action taken by the president, or at least on behalf of the president. And the president has a lot of power.
Thank you. I see Jolene has her camera on. Jolene, do you have a question?
Well, I didn't specifically until Lori put a question in the chat about, does DEI messaging from the administration also include disabled? And then Kathy said, does that also relate to Section 504? And I was going to ask, kind of related to those things, if you foresee any challenges to the protected classes.
Yes, for sure. I mean, first of all, there have been more than challenges. There's been an obliteration of some of the protected classes, and where they're not protected by statute, well, that's within the president's power. Where the protected classes are protected by statute, then the president has less discretion. But trying to define what qualifies as discrimination and what doesn't qualify as discrimination is very much up to, if not the president, an agency acting on behalf of the president in interpreting and implementing a statute. And every action that this administration takes in that context is going to be consistent with the letters that they've sent out. They're usually 3 or 4 pages long, in which they describe in detail the way they interpret the Supreme Court's 2023 opinion, and say, if you cross us, if you do something that is inconsistent with that, you'll lose all your funding. And again, my advice is, unless you want to make yourself and your agency a sacrificial lamb, I just go with whatever they say, because they do have a fair amount of muscle behind them in the form of the Supreme Court opinion.
So there was another question in the chat, based on what is happening to the housing sector, how would you predict other sectors to be impacted, such as environmental, economics, et cetera?
Well, it's going to depend on the sector to some extent, but I mean, broadly, I mean, he wants to gut the administrative state. He wants to reduce to its bare minimum, except in the context of immigration, of course, reduce to its bare minimum the power of all agencies. And there's some contexts in which he's more dedicated to that than others, and he's likely to prioritize some contexts more than others, but that is his overall objective, and certainly it's Elon Musk's overall objective. And so what I expect them to do is go straight through agency by agency, and through a combination of terminations of employees, eliminating, in some cases, maybe 10% of an agency staff, in other cases, 90% of an agency staff, reducing significantly the power of the agency, and in the meantime, interpreting the statutes under which they operate in ways that minimize the power of the agencies to do anything except rescind prior rules. They want them to have that power for sure. This is going to go through agency by agency, but virtually all agencies except ICE are going to be in a similar situation. And whatever, I think the courts will erect some kinds of limits on his power at some point in this process, but I don't know where they're going to be. And I do know that he has enough power that he clearly can exercise to destroy an agency in terms of destroying its institutional culture, its institutional memory, its ability to function the way it has historically. I'm not at all confident that any court has the power to keep that from happening in the context of any agency that he wants to attack.
Okay, so for people asking questions in the chat, if they're really like HUD and program specific questions, Professor Pierce may not have the answer to those. Before we get into a couple of those, so to specifically answer the question that Laurie had, so does DEI messaging from the administration also include disabled? And then Jolene had a related question, but I don't know if we actually answered that one. So do you know if the DEI directives include any special treatment for the disabled?
So I'd have to go back and reread the many versions of the DEI letter that I've read that have come from various agencies. I do think I do recall some reference to disabled people, but so that certainly wasn't the focus of the Supreme Court's opinion in 2023 in Students for Fair Admissions versus Harvard, and it's not clear to me what the Trump administration's agenda is in that context. I don't think that they're very sympathetic to the plight of disabled people, but I don't know how far they're gonna go in that context. I can see somebody wanted me to provide a copy of the letter. I mean, I've got a dozen of them that I've received. They're all about the same. They're everywhere. You can find them very, very easily. The same letter they've written to actually the Republican-controlled states' attorney generals have written to the American Bar Association, telling them they have to eliminate all DEI programs 100%, or no federal employee will be allowed to be a member of the ABA, and the ABA will no longer be authorized to accredit any law school. But they're sending them to everybody who receives a grant of any sort. So they're all over the place, and they may vary a bit in their wording. They're really very pointed in terms of racial discrimination. There's if they've got references to discrimination against the disabled, they're much more terse and I didn't really notice them much, but they're all out there. If you haven't gotten one yet, I'm kind of surprised that your agency hasn't gotten it. You will.
Okay. All right, let's see what else is coming in. Alice says maybe it's best for us to really dissect the letters that come from the specific agency that provides the funding for the programs we have in mind. I would think that that is correct. So going up to Nicole's question, so I don't know if this is something that you could answer. It's kind of more philosophical question, even though it can have specific applications. So Nicole's asking, if we have executed agreements with HUD for grant funding from prior years, should we hold off on entering into subrecipient agreements to expend those funds, since it appears there is a risk that the funding might not be there when we need to draw it down to reimburse the subrecipient for the completed work?
I have no idea. Absolutely no idea. You should recognize, as I think you already do, that you're in a very uncertain environment, and act accordingly. There are going to be more changes every day in this administration.
So this is a good question. This is kind of a predictive question, asking your opinion. So the Trump-Musk alliance, do you think the goal is wanting the private sector to take up a lot of the work that the public sector currently does? Or in addition to gutting the administrative state, removing the funding as well?
I'm sure that's part of the agenda, but it goes beyond that. There are a whole lot of things that agencies have been doing for decades that the Trump administration and Elon Musk individually and Donald Trump individually think shouldn't be done by anybody. Okay, and so part of this is sure, we want to get the government out of the way so that private actors will have more freedom to act, and that will, in some circumstances, some contexts, create private actors that are able to fill in the gaps that are left by the departure of the government from the scene. But in many cases, they just don't think it should happen at all. I mean, their attitude toward foreign aid is not it should be done better. Their attitude is it shouldn't be done. You know, that's why you start with an agency that I don't remember the total number, but they at least attempted to whittle it down to 300 people, a tiny fraction of the original workforce. You don't do that because you want some incremental improvements in the way that financial aid is distributed. You do that because you don't believe that financial aid is a good idea. Foreign aid, I'm sorry, foreign aid.
So another question that's come in, this is coming up not just within the agencies that our members are serving in their communities, but I know just generally because of the DEI directive. What's your take on using synonyms to rename offices or programs, or sort of generalizing their goals, like around fairness, for example?
All of the letters are explicit on that. If they catch you, you're toast. And they're specifically looking for that. And this is a standard move. I've seen it done by many organizations already, where you take the people who were in that office, you rename each of them, and you rename the office, and you hope they can still perform the mission. And the message from these letters is, don't try it. You're toast if we catch you. And I take them seriously. They will be specifically looking for circumstances like that. And if you try and protect, the former head of DEI by renaming them, protect the DEI function by assigning it to some other department, well, you're taking a big risk, because they're going to be looking specifically for that kind of action. And if they detect it, they're going to just jump right in and say, that's the end of your grants. You get no more federal funds.
Mm-hmm. I want to go back up to this very first question, which is maybe not one that you can answer, but so fair housing is an important thing, in our world. So can you address fair housing rights and obligations, which in the past have been enforced by HUD? Are the fair housing rights and obligations in the same bucket as DEI? Do you know?
Absolutely. Yeah. No, they have no sympathy at all for them, and so they will do their best to gut them, to make them unenforceable, to cut funding to anybody who tries to make them effective, et cetera, et cetera. They're not at all sympathetic to anything of that type in any context.
Mm-hmm. Okay, any other questions for the chat, or if you'd like to take yourself off mute? Okay, well, we may have, another one pop up. Going back to your discussion of the Impoundment Act, so something that I've been wondering is, as we're hearing about staffing cuts that are going to be made to HUD and specifically the Community Planning and Development Department, and I think I mentioned this to you, like when we were planning before we fully got on here, I'm interested in, so, it's one thing to cut grant funding itself. It's another thing to just cut the staff, which essentially makes it much, much harder to disperse those grants. Going back to the issue of impoundment. So if we find that a majority of staff that are responsible at the federal level for dispersing these grants have been cut from the workforce, can the administration then take back funding that has already been appropriated even for prior years? So not even talking about, the budget process that's happening right now. And that's kind of related to the budget freeze that happened. So they tried that. Could they try to do the same thing with certain years of funding?
Well, they're certainly going to continue to try that, and if and to the extent that federal district courts and circuit courts block them, they're going to be going to the Supreme Court, and they will make exactly the same argument in every case. Each of these many cases before the Supreme Court. We don't care what the statute says. Article 2 of the Constitution vests the executive power in the president, and so Congress can't stop us from doing that which we want to do. And as I say, I don't think the Supreme Court's going to agree with them in all of those cases. They're going to agree with them in some of those cases, and trying to figure out in which cases they agree with them and in which cases they don't is hellishly hard. Well, it's impossible. Most of us can predict the way 5 justices are going to vote, and that means, but that means that we can't predict the outcome of any of these cases because we can't predict what the other 4 justices are going to do.
Okay. Donna, I think your question might be a little too technical for HUD, but would there be a requirement for the certifications to be updated before the 2025 grant applications plans are submitted, specifically the affirmatively furthering fair housing, which are required for HUD entitlement programs? So Donna, is your question like around, should work as usual continue essentially until we know otherwise?
Yeah, it's I certainly can't answer that specific question. I can say that generally these people are moving as rapidly as they possibly can to implement their agenda 100%. And that means that they know that they have to take tens of thousands of actions. And they're moving as rapidly as they possibly can, but predicting exactly when they'll get around to each step is a fool's errand, and then predicting the reaction of the judiciary is and of course the other thing that's important is how the public responds. So far the public has responded by applauding what Trump and Musk have been doing. it could well be over time that people start seeing some tangible adverse effects on themselves or their relatives or their neighbors or their friends, and then public opinion changes, and of course that can have enormously important effects. So far, he's riding a crest of favorable public opinion. His favorables just keep going up every time he takes one of these actions.
Yeah, thank you. And thanks to Jennifer for making a plug for the legislative conference. So she's correct. And I put a link in the chat for everyone to sign up, even if you can't be here in DC for it on Friday. So this is the Friday of next week, the 28th. It'll be fully online. So please sign up. We are hoping to have some of the political leadership and hopefully the career leadership from HUD there to answer some of these more specific program questions. So please join us for that. We've got a couple more in the chat, and we've only got about 4 more minutes, but I see Tiffany raised her hand. So Tiffany, if you'd like to go ahead, and then we'll try and get through the ones that are in the chat.
Hi, Tiffany Otis, City of Salem. Piggybacking on the things that were just put into the chat there and that the professor was trying to answer, and maybe I will just get my answers at the legislative conference, but we're in the middle of a con plan starting up with our 2025. So this is very pivotal moment for us about language and, you know, what to be putting in for documentation purposes, besides, like somebody's already mentioned, all the subrecipient agreements that already are in existence, let alone new ones that would be, you know, coming up. So it just seems to be damned if we do, damned if we don't, and still need to get things out. But will we get paid? Will they get paid? You know, very untimely for everything. So thank you for your information and responses.
I'm afraid, Tiffany, you have captured the situation quite accurately. And I'm hoping the next time I address you guys, if I ever do again, that I will have both more definitive things to say and more optimistic things to say than I do at present.
All right, last question. Can fair housing be removed altogether, even if it protects against discrimination per the US code?
The only discrimination this administration is interested in is discrimination in favor of blacks. They want to eliminate discrimination in favor of blacks. And they believe, and I'm certainly not owning this or any of their other positions for that matter, but they believe that there is a lot of discrimination in favor of blacks that is going on right now, and they want to eliminate it to make things more fair for whites.
All right, on that note, my last question for you would be, Dr. Pierce, are there any opportunities, you know, any signs of hope, anything that we can look to try and end on an optimistic note?
Elections.
Okay.
The off-year election will matter a lot. One of the things that's going on is during his first administration, Donald Trump appointed 226 federal judges to district court and circuit court positions. Most of those judges were way to the right of the 5 conservative members, 6 conservative members in the Supreme Court. They got very little attention. If the Republican Party continues to control the Senate after the midterms, he will get another 200 and some judges who share his beliefs and they will be all people in their 40s who can serve for decades in the federal judiciary and will then dominate the federal judiciary. If the Democrats retake the Senate in the midterms, then that process will stop and he'll only get 100 and some of his handpicked people into judgeships. So midterms matter, and of course presidential elections, as now should be abundantly clear, matter a whole lot.
Very good. All right, well, thank you so much for addressing our group again. I do have a feeling that we will have you back So thanks everybody for being on and for your questions. Like I said, please do join us at the legislative conference next week. Maybe we'll be able to get a little more specific information out of HUD. If we don't have them there, we'll be working on setting up a call with them at least sometime very soon. So thank you, Dr. Pierce, and good luck in all of your work as well.
Thank you.